because we actually have this link, I kind of request you to share it with your colleagues who are supposed to have joined the space. We may be starting in the next 5 minutes. We shall use this time to share the link to the space to our colleagues so that they can join this amazing conversation tonight. Thank you. We will be beginning in the next 5 minutes. As of now, I request you to share the link with the colleagues who are yet to join. Probably they are looking for a link from Mr. Sony's particular handle, but we have some network challenges and we'll be using this link. Thank you so much. Everyone who has joined us today, if I understand you're trying to join in as a speaker, we already sent the request, the invite to speak. Yeah, so ladies and gentlemen, we are once again, I welcome you to this 8th episode of the Judicial Service Commission Conversations. I thank you for all of them, all of you who have been with us since the first episode, and I welcome you to this 8th episode of the Service Commission Conversations. Yeah, ladies and gentlemen, justice has been rigged by case backlog, and we cannot just keep looking on as the trend continues. And because nobody can and no one will stop reggae, we are here once again on this 8th episode of the Service Commission Conversation. Due to case backlog, the temple of justice has become a temple of injustice. Our courts are being swallowed by the cases they are supposed to better handle. And in addressing, so we need to address this issue where our courts are being swallowed by the same cases which they are supposed to handle. And in addressing case backlog, we are not only simply clearing the list of cases, but we are restoring the faith of the Uganda justice system. So in addressing this case backlog, we are not simply clearing the list of cases, but we are restoring the faith of the. I understand case backlog is a big challenge, but in innovative. The innovative solution we have is according to different cases. I've so far had 7 episodes of this service in the age of different judges, and you people have been a wonderful audience joining us every Wednesday at 7 p.m. Others join us on Express here, and others join on our YouTube channel, Radio in watching the convention live, you can do so on the YouTube channel Reggae Plus One. And because no one can and no one is not reggae, my name is Alfred Liaka. Today I'm also the co-host this convention together with Jason Karuhanga, the lawyer's lawyer, Mase Kentai, our user female representative on the space. And I'm also the host Amfra Tegeka, blessings from Ginger and Prime Secretary of the Radical New Bar. Now, I've been working Ginger for quite a number of years, for 4 years, as a legal clerk. I have found memories of Amfra Tegeka. When I was working there, I was a law clerk, and I used to eat money for commission investment. I ate the money, but you know, you understand, just commission for me. It's a very good case. I have found memories of working in Ginger. So today we'll be sharing with us how the experience is still in practicing Ginger, how case backlog is affecting people in the Western region. I'm super overjoyed to co-host Eddie, I'm Secretary of the Radical. Watch any of them live, you can go now on YouTube channel Reggae Plus One, follow live. Others can remain on next space, and as requested, you can keep sharing the link. Before we go deep into the conversation, let's introduce our other co-host, like Council Maxi. I will first have just a quick chat with Karuhanga on how the trial is, what is happening with the service commission, when I already happened to other people and Karuhanga, take it over just before we go to the conversation.
process began long after our campaign was injuncted. Some kind of limbo shows the energy that is needed. But it also shows, and it's good, Eddie is here, Eddie Nangolo, who is the secretary, who is the, actually, officially is the council member for Eastern. Challenge we have now is we are being asked when is the date. We need our date, we need our election. The choice members of the Law Society have and the opportunity they have is incredible, and it's constitutional, and it's democratic, and it's proper. Acceptable that for so long the hands of our democracy have been tied, the hopes of our people have been set back, and this is something that we are certainly working on. On our part, we were not happy with the decision which came out of the High Court. We filed in the High Court, and then we filed in the Court of Appeal, and we shall be pursuing remedies there. But I am humbled when you said 8 weeks. I have not actually having this conversation for 8 weeks, and it is an absolutely incredible conversation, and I am so honored and humbled that whatever has happened, whatever the delay has caused, whatever injustice and inefficiency and discouragement it has caused, I'm happy it has given us an opportunity to have a full debate with colleagues about what's happening in our courts and what's happening in our practice and what's happening to our people who are our clients. So thank you for that. And I'm also very happy to have Eddie here, and also to have Humphrey. I don't know if Humphrey has been able to get on. I also was having challenges getting on. I was able to overcome mine. I hope that Humphrey, you can overcome yours. But welcome, Eddie. Eddie, for those who don't know, is council member for the Eastern, for the Uganda Law Society, but he's the energy and the engine for the stuff that's happening in Acacia. He is he's beats like the beat of a radical new bar. It beats with the rhythm of reggae. And we're happy to have you here, Eddie, and yeah, welcome.
No, just
conversation. Now, for us, even from where we are coming from, we are deeply aggrieved by the state of our courts. We are deeply cannot indeed execute as effectively, even if he leads us honorably. But we are seeking to stay orders issued against him, and the courts are just sitting with their hands unbothered, indifferent about the situation. The Kiza Besigye story, the Karamajong situation, the ones that were before the court martial, and many other situations are stories that we've been trying to highlight to indicate the plight within the court system. Sadly, those conversations there haven't been hard enough. And when these spaces here occur for us to raise those voices, raise those concerns, we must come. And I am indeed pleased to be part of this conversation. I have a lot of thoughts to share, my personal experiences. I hope I can just pour them out. I am thankful to Ellison, my brother. When you began the slogan, "No one can stop reggae," I think I first caught onto it when we were waiting for the ruling from the High Court on the injunction. And it was called the Injunction Waiting Party. And we were waiting, and indeed the songs we were playing and the hearts of the members we are beating, those beats continue. The songs and the reggae tune has never stopped.
Thank you, but there's one issue of backlog which I think you forgot to address, the issue of Alfred's wife. Maybe it should be addressed here so that at least at this space we have mission-based things and backlog is cleared.
Now, I met recently. I met Alfred. I met him recently in Mbale, and excited, and he was walking around, and indeed we had a positive discussion. We shall find the wife. We shall find the wife. He set the stakes so high. His conditions were a bit high, but indeed we shall meet those standards. He will have a wife.
So in that case, the backlog is being caused by the pleadings.
And the standards he's setting, the prayers he's making.
I don't know if Humphrey has gotten on yet. But maybe we can
We can begin with.
maybe we can start with you, Eddie.
Yes.
And first of all, I think many people know you. So maybe as a first introductory question is, while people may know you, maybe you can tell us more about Eddie Nangulo. What made you think of joining the leadership of the Law Society? What makes you tick? What makes your heart beat faster? Apart, of course, from helping Alfred to solve his very serious challenge. Yeah. Tell us about yourself.
Now, when I joined the practice, somehow I joined much earlier than some of my other colleagues, but also I joined at a lower level. We joined as clerks and office messengers running around documents here and there many years back. But I don't want to skip so far ahead. But what I want to draw from that experience is that we got to witness firsthand the apathy in the court system. We got to witness firsthand how corruption indeed can undermine justice, how rights of individuals are neglected, disregarded, and how the indifference of the court is indeed a very heavy price to pay. Times when you would go through our different court journeys, you'd really see how the individual and the let me say the Muntu Wawansi would struggle with the seeking recourse before a court of law. Now, many of those situations began to shape my idea of what the practice should be, of what even we should be able to experience, what the court should be like. And when we began now to practice, we really felt that we should make a difference. We should impact, we should reverse the tide. So when we began to practice, I remember when I got my first PC, I quickly was a partner in my first year of enrollment. One of my colleagues whom I'd worked with really felt that indeed you can make a meaningful contribution. Joined me as partner. But the ordeal, of course, of a young advocate, and even whether you can ably negotiate with a senior colleague, for favorable terms is a telling story of every other advocate joining the practice. Now, beyond even the shortfalls within the law, the practice was increasingly struggling. Ellison lawyers were struggling, mostly the young lawyers. Lawyers were burdened by debt. People would wear suits, but would struggle with meeting basic necessities. Now, it began to disturb me, and I felt this can't be us for 5 or 10 years. Now, in the regions, we don't even observe the advocate rules on payments for our court fees and the rest. People will just go with as little as possible. Now, that is what, again, even caused a bigger problem. Now, you will observe in our further conversations, even when I met the president, when he was bidding for his ULS presidency, he ran on a strong agenda of improving members' welfare. And that was by having our statutory provisions modified to fit into the current times. Now, those conversations began to occur, those discussions began to occur, and they began to really make me uncomfortable where I was. Seeing our colleagues struggle made me uncomfortable. Fast forward, I sit down with the president before his nomination, and when he comes and we discuss what do we do about the rule of law, what do we do about the ongoings in society, what do we do? Do we go on to fold our hands? Do we go on to ignore the impunity, the corruption, the abuse of rules and procedure? What do we do? And in asking those questions there is when we began to now invent what is the radical new birth ideology and the 2060 vision. Now, as a matter of fact, from that conversation is where we designed an agenda that we are now fronting under the Radical New Bar, and it's what we are pushing forward. So when you ask me what brought us here, it was largely and majorly the plight of our people, those that we serve, those we represent, the apathy, the difficulties, the overbearing burdens of the court system, bearing on the individual, bearing on the citizens, and no recourse is being offered at the court or at any other fora. So I'll go on, I think, discussing as we carry on. But I think if you ask me a question of who am I, when I sent you my profile, I had said we are judicial reform activists. Indeed, we are pushing for judicial reform, and we are going to dedicate and devote as much energy that we have within ourselves under the Radical New Bar to change the current status quo. Things must change.
From your conversation, you realize basically the temple of justice is now becoming a temple of injustice because of the case delays. And you say, if the rates of for us who are a bit privileged can be stepped on, now you can imagine the rates of the common man. When you say that, I imagined there are now 8 pending cases involving ULS and the president, maybe President Semakade. And if the rates of such who are, let me say, privileged can be stepped on, now you can imagine the common man. Now, from your experience, I realize you have been working with the low-income earners or on the ground, let me say. So I would like to get from you, from your experience, what do you think is the primary cause of the persistent case backlog in Uganda's judicial system?
Well, thank you, Alfred. I think Backlog for us is a song that has been sung for many years. It is an old tune. I think it has even lost, even the policies being addressed, trying to offer recourse. They are all old songs. but we haven't gotten to understand what is the problem exactly. For me, backlog is stemming from our statutes. And our president calls these colonial enactments that have led us to where we are today. If you look at our criminal laws, for instance, if I may just start from criminal procedure. When Kizza Besigye was charged before now the civilian courts, a number of persons were celebrating and they were happy that indeed now it is the right forum, it's the right court. But you'll discover that the principles on committal are one of those policies that indeed occasion or even are the leading cause of backlog. You'll discover that now, because of the need to present someone before a court lacking jurisdiction, present someone before requires that before you can even commence someone, even before you commence proceedings, there must be a session set up. Sessions require that a judge must designate a number of files. They must designate assessors. They must pick advocates on state brief. They must determine what shall happen in a given session before they can begin to present you. Now, the average waiting time for one to be on a session is between 5 to 8 years. 5 to 8 years of waiting is a big problem. These are pre-trial penalties. That right now, why even you have a lot of anger from RNB and the president when Abodo charges the Kisumu 36 persons with a capital offense. She is indeed condemning them to the burdens of our legislation, that they must go through committal, that they must wait for a session, that they must... Now, the beauty is for them they got bail because of their persistence. But there are other persons that are unable to apply for bail. Under our bail legislation right now, if you cannot prove illness or advanced age or those rather serious grounds to justify the grant of bail, you can never be released. Now, for the younger and the healthy people, under 35, healthy, you've fed well, you're eating healthy, once they arrest you and they detain you in a capital offense, you can't obtain bail because you can't prove medical grounds, you can't prove advanced age, because indeed they'll say that you're healthy and you're able to endure the prison conditions. Now, how is that even proper? How is that even fair? But because of sessions, we are forced to wait. Then you add on to that assessors, another relic from back in the day. We've kept on saying assessors need to be removed from our legislation. We must repeal the laws introducing assessors. The basic principle is that assessors were set up then to advise the foreign judges on our customs and our local practices. Now it's our judges. Where I come from, in Mbale, where I come from, the judges are Abagisu, they are from the region. Now, how does an assessor sit by and confidently also advise a judge on his own customs, his own practices? And we are saying we cannot commence a session because there's no assessor or because we must appoint assessors. These impediments here are what indeed result in the backlog we experience. For someone to wait for 5 to 8 years because they are waiting for a session is a pre-trial penalty. It is illegal, it is improper, it shouldn't be happening in this current day and age. That is under our statute. There's so much I can say. But our second, for me, I think our second biggest cause of backlog is in the judicial mentality of unaccountability. Even now with the new act, a judge shall be paid until long after retirement. They will go on to earn. So there is no sense of accountability. There is no sense of servanthood. We always say this in the East, that the titles are being abused. By calling someone my Lord or your worship, there is, I think the titles get to the heads of our judicial officers and they develop a sense of unaccountability, that you'll even have to appreciate them and thank them where a decision is baseless or is without merit, through obliging, through most obliging, whenever they make a decision. It was being said one time in one of the spaces that we even thank them for bad decisions. Now, you are seeing an obvious injustice, but you must thank the judicial officer for what they have done. The other day in Mbala, I took on an appeal of a child who is aged 14 years. She's a girl. The girl was charged with defilement. Now she was sentenced. To a term of 2 years. Now this girl is at the time of the sentence she was. I'm being heard? Am I on? Yes, I was telling you a story of one of my own experiences. A child, 14 years old. She's 8 months pregnant. I keep on going off. I hope I'm not here. So I hope everyone is now muted. Can you hear me now? No. Okay. Now I'm on. Yes. I was. Please forgive the network. It is one of those issues that occurs with technology. But I was giving an experience of just two days ago. I took on a new matter of a girl who had been sentenced. She's a 14-year-old child. She was charged with defilement. At the time of her sentence, she was 8 months pregnant. And she was now that is illegal for starters because of the age, because of the mitigating factors. I was being told by the remand home that they don't have means of keeping the child because she's a first-time mother. She's supposed to deliver, so we began to run a different course to try and secure bail. But this goes to tell you that even where there is no legal basis, our colonial system has required us to oblige and to be thankful, even for what I would regard as bad judgments. When we reviewed the Supreme Court judgment of Kabaziruguka, we felt that indeed the Supreme Court had given with one hand and taken with the other. And why it can't even be enforced now is because of the lacunas in that decision. People's rights have been violated. They're going to be violated. And we are having a court seated with arms folded and bothered. There is really need for concern. If we can't be empathetic, then let's sympathize with our people. So those for me would be the leading causes for backlog, if we sort out those two, if we sort out our statutes, if we sort out our legislation, and if we reintroduce a sense of accountability, the bang the table mentality, when we pushed the Supreme Court to deliver the court-martial judgment, it was one of the avenues to demand judicial accountability. And we've kept on saying Radical Nuba won't apologize when it comes to demanding for what is rightfully ours. We won't even thank and plead for what is rightfully ours. I think even the title pleader referring to lawyers even also maybe would reduce our relevance. We must demand for rights. To plead suggests that as though you're going before a God and a most holy place and you're using titles of my Lord, the bench isn't helping us. The bench is largely a public servant. These are public servants, glorified public servants. They should serve the interests of the country. On a different day, in a different place, in a different time, if these were elective positions, none of them would be returned. But because of how they have covered up themselves in colonial establishments, they feel they're untouchable, the system can't touch them, they can't be sanctioned. You'll observe even recently when we were raising complaints about members of the bench, all those were ignored. And that is why JSC for us is an important place. The radical surgery is critical. We are going to push this agenda because without this surgery being done, we can't talk about justice. We can't talk about rule of law. We can't talk about accountability. It stems from the head, and until the head is addressed, everything else would fall by the wayside.
Yes, Mercy, I understand you're on call. Please, the audience needs to listen to you, and you could be having some questions before we proceed to maybe another question from Mr. Elson. Mercy, can you hear us? Yes, we can. Yes, we can.
Yes, after my question is really along the lines of keeping in mind that this is an issue that you state because the laws, it's in the way things like what do you see as the quick alternative or the quick option in light of what needs the judiciary has already trying to appoint more judges in the different sessions? Do you think that these approaches are supporting our existing laws to maybe make them
civil sessions in Jinja? We had been for a long time demanding that the Court of Appeal walks out of its shelter and come and serve the public and the regions. We had the first session in Jinja about 2 weeks ago. I was having matters coming up in the session, and I told the DCJ, what I want even to repeat now, is that their innovations and their inventions are not well thought out. They are coming extremely late. That's the first thing. That all meaningness, all meaning is lost, or whatever they intend to achieve is lost because of how they are approaching this whole situation. For example, in that session there, I was having a case, an appeal, which was 10 years old. This is an appeal just. The trial had lasted for about 5 years. This is about 15 years average. that someone is pursuing a land dispute, it can't be meaningful. That even if you come with your platoon of judicial officers and say now we are having a session, it doesn't really represent you as indeed being concerned about the plight of what is going on. 10 years for you to sit by unbothered in an office is a long time. Now the same cycle continues. We had the same DCJ in Mbale, and then we were launching the digital system, and they invited one of the inmates to enter a plea bargain. Now he's making a plea bargain agreement 8 years after he was charged. 8 years after. That is as long as his sentence would more or less be. And we are unbothered. And I asked them then, why are we clapping about these things? How do we clap? How do we clap that we are launching a system? Okay, yes, it is a good system, but the person who is saying the terms of the plea bargain are agreeable to him has already served 8 years. And he has already been condemned. He has suffered a pre-trial penalty. And he's being released. And even beyond then, the system, when they are releasing you after that length of time, there is no thought on compensation. There is no thought of how do we even rehabilitate. Someone is released, and what is even most shocking is that the accused person celebrates and feels that indeed I've been released, or maybe they have had my case. This is how bad things are, that even us, we don't know what is due to us. We feel we are being rewarded by sessions. We feel we are being rewarded by hearings. These are rights under the law. That if the court cannot try your case expeditiously, they should release. If they hold you beyond then they should pay you indemnity, or they should compensate for whatever damages you have suffered. But when we talk about these policies being mooted, in my opinion, they are, I would say, in bad faith. It is just, I think, to slap us in the face. These are slaps that, I think, say the least, Ellison, honestly, because I've been in these plea bargains, and when they put something before you 8 years after honestly, and they are maybe saying you can maybe spend two more years, then you release it, you take it. There is a lot of coercion. It is there's undue influence upon the mind of the accused person, that you will just accept what is being presented because the system has already pressed you from all sides, all angles. You've been burdened by the penalty, and you walk out of there and people are clapping that indeed there is justice in this country. We're doing badly. It is extremely, extremely terrible. And watch the space for Kiza Besigye's situation. The beauty with him, of course, is that there will be a bit of noise. He will not maybe last that long. But just watch the space. He's going to highlight where we are failing. That me, I would even think that if you would have wanted a trial, doing so in the civilian courts is even worse. The civilian courts, how do I say it? Civilian courts, unlike the court martial where it was illegal for them to indeed impose these burdens, civilian courts burden you lawfully. They will mention your case lawfully because it's in the law. The civilian courts will have you wait for a session because it's in the law. You're going through committal. You're waiting, and it's lawful. But now you can't say I'm under illegal detention. It's lawful. And they won't even pay you because the law has permitted them to treat you in that manner. Some things really need to change. They must change yesterday. Let me also say one more thing about mediation. And for me, this is where I disagree with the proponents of mediation. Yes, I agree in one way that it is well-intentioned. And in many ways, it is a mechanism of resolving disputes quickly. But why should we front a process that indeed undermines litigation, undermines the legal system? We're telling you settle your case because you won't take 5 years. Why is that the norm? Why can't I settle my case because the terms on table are agreeable to me? The proposal is sensible. The figures are within what I would permit. But the biggest proponent of mediation is the shortfalls in the system. And it's even sad that this is being highlighted by the bench. It is the bench who are saying we are unable and we are failing. So we cannot attend to your matter. We can't give you a quick trial. But why is that? Why is that the case? Why don't we find solutions to deal with that problem there? Why are we highlighting and offering a lesser proposal? Like for instance, if you would have received this much, if they've abused my rights, let the courts pronounce on that abuse there. What people don't know is that through litigation, we set the terms that we exist in community. Society now is able to understand if you act in this manner here, there is this penalty. But when we choose to have it done quietly, the anarchy and the chaos remains. The situation is unaddressed, which for me is a big, big issue. That if the court wants even the advocates to back them on this issue here, let it be a better option, not a lesser evil. Let it be a better option, not a lesser evil. So in my honest view, many of these proposals aren't in the best faith. And now the judges who are pushing for mediation, for me this is my individual opinion. The bench are trying to retain a level of relevance beyond retirement. The persons who are pushing for indeed these setups are the ones who are in their later years, and they want to say that they are able to offer a meaning alternative to the court process. Let the bench and the proponents of these procedures sort out the mess at the court. Let us accord timely justice. Let us accord meaningful justice. Let us cast out judicial impunity. Let us cast out corruption. Then we will have a meaningful and proper society. But they want to retain, and this is because they don't want to come back to the bar. We keep on saying, when you serve at the bench and you retire, the bar is your destination. Return to the bar. Let us practice at the bar. You're experienced in whatever levels. You've served at the Supreme Court. Return to the bar. Let us now litigate and again reshape the scope of jurisprudence. But they want to go and hide behind the table, maintain the title of my lord, but negotiate outcomes. I strongly think that it is not well intentioned. If the bench would empower the bar and empower the systems of litigation, we would go so far.
That was quite insightful. Yes, Mercy.
And that the different creative ways that the judiciary is trying to implement are not solving the core issue, which is the law, and also the fact that it's not timely, that it's already late. What does justice look like for an ordinary citizen? One of your clients was
When with the ongoing state in which the bench is treating the bar, it's even more dire. We keep on saying that the bar is the voice of the public. The public are the ones that are indeed the seekers of justice. You can't lock out the bar. You can't deny or prevent the bar from litigating or appearing in matters. Now, why I say it is dire is, and this is said by the president often, he calls them big egos. That the egos of the members of the bench have clouded indeed the purpose of the appointments. They have clouded why indeed they are serving this country. I would say it again, these are public servants. These are public servants. We must bang the table. We must redirect the course of our jurisprudence. Why our president says, and why even we say that there won't be an apology for these demands, is because indeed our rights under the law. The titles of their lordships and presenting our rights, they should attend to those rights and not expect that or think that they are rewarding us for what is due to us. So mercy and ride over anyone standing in our way, because indeed there is no turning back. When Edison here says that no one can stop reggae, we intend to bang the table at the JSC. We are going to meet His Lordship Singiza there, and indeed we are going to try to restore sanity in that place there. So much as it is dire,
Someone also raised the issue of, I don't know if it was Prima or Linda, is the issue of I think the way you've explained plea bargaining, I think if we introduced timelines for hearing of these matters, then like I think the person gave, I think it was Linda actually, gave the example in the US where plea bargaining settles most cases. There's only so much time that your case can remain in the system. So there's a time limit to how fast you must be prosecuted. We had a guest from South Africa who told us about the timelines for what constitutes backlog in South Africa, and it became clear to us that if South African backlog is Ugandan jet-like speed, that if the case went at the speed of a South African case, it would be prima facie evidence of corruption. We certainly need to have a proper review of the entire process. But one of the arguments we've been making here, beyond all the general reforms, is the issue of mission-based judges, based on Article 142, Clause 2 of the Constitution. And our argument has been, because yes, I hear you, there are all these challenges. But at the same time, we are seeing judicial officers overworked and overburdened. And we've gone into the courts as well. I don't think we can just condemn the judges only without also understanding the conditions in which many of the colleagues who sit on the bench are practicing. I mean, someone is sitting for 16-hour days, handling 1,000 cases before them, with a backlog growing. A judge told me that he was appointed judge on Monday, and on Wednesday he had backlog. This is a senior judge in Uganda. Told me that he was appointed a judge, he went to parliament, he got approved. This was about, and this was, he had this experience about 10 years ago. He was appointed, no, actually, he's been a judge for about 20 years. So he was appointed 20 years ago. And 20 years ago, in that week, his lordship had backlog. The system as currently designed, because I heard you talking about mediation. In particular, has become like a ransom. The criminal justice system seems to be holding hostages at ransom. Accept and get a lesser sentence. Fight and take and you'll serve your sentence on remand. Yes, there are all these challenges, but where do you think mission-based judges fit into this conversation? Because we have been firmly pushing for the idea that we need to have mission-based judges. And we need to have mission-based judges being judges, and for those who don't understand mission-based judges, it's based on Article 142, Clause 2 of the Constitution. It's already in the law. Where the state of the business of the court so requires, the Judicial Service Commission shall advise, and the President shall appoint advocates to go into the courts and help carry the burden. And when you finish carrying your burden, you go back into your practice. No pension, no official car, no whatever, none of the pomp and circumstance of judicial office.
Recently, and even for some time, the bar has a depth of experience. There are persons who are seasoned who would not maybe make the cut because of a number of situations that occur within the JSA, but they can indeed serve this country honorably. They have they've practiced, they understand the law, they understand the procedure. And no one better understands indeed the plight of these of our clients more than the advocates. So I entirely agree that they are a step in the right direction. If handled, well, if even properly designed, it can go a long way in addressing the backlog situation. Maybe say pick an Ellison from Central here, and maybe let him hear matters may be arising in Moroto or in Karamoja, where he has no actual connection to the situation. It would even serve best for, say, matters that are criminal. Because where would somebody take 8 years waiting, yet the evidence available is clear. It's glaring, for instance. And we have done these trials, but you have him wait. Maybe if I may even just add this strong point. Our current system of justice, mostly criminal, actually it's actually criminal, doesn't aid any of the parties involved. The accused person doesn't get to have his day in court because he is penalized before his trial and forced to sign a plea bargain agreement. The victim of the crime, after those 8 years, say she's a girl of 14 years, after 8 years should be about maybe 20. The prosecution, the state, the victim, no one is benefiting from the ongoing situation. So when your idea is mooted, indeed it makes logical sense. It's appropriate, it is meaningful, it's timely. I think it is even necessary because where we stand today, you cannot know it's done, let us get out of there. It would go a long way in emptying our prisons, or at least even allowing persons have their day in court in a timely manner, but even also allow them serve their due time and not serve a pre-trial penalty, and then no one can indemnify you for that time.
That someone who has sent them on a mission to clear any cases. So I would like to get to understand from you what safeguards can be put in place to safeguard and preserve the judicial independence of the mission-based judges once they are appointed, just in case we go through and they are appointed. Thank you. Yeah. Session has confirmed that mission-based judges are going through. So I would like to hear from you what safeguards can be put in place to safeguard the independence of the mission-based judges, so that we don't have the same scenario with the current judges where some of them are not independent. We don't want it to happen to also these mission judges who are coming on a mission and also not independent. So these ones want them to be independent. So what can we do for them to be independent? Thank you.
Okay. What bothers me even till today is why we still struggle with judicial independence. I think we have moved a long way in having the relevant laws in place. to enable the judges enjoy independence of thought and maybe independence of actions. But still, they struggle with chains of overreach by the state. And for me, this one here, I think, goes back to the state. If we are to, for starters, agree that the law is supreme, that our constitution is supreme, and every organ and every arm of government appreciates that indeed they are subject to the law. And then number two is that we must respect the independence of the different arms of government, because each of them exists to check the other. Now, one can't begin to overstep or overreach into the other's mandate, and we think we shall enjoy that degree of independence. This has been, I think, one of the earliest first-year questions. We've been asking ourselves, why do we have judges appointed by the president? Every other meaningful democracy has walked away from that chain that holds them back, because indeed through the appointment mechanism you set up a system of either bias or of lack of independence, that because I know you must appoint or you must reward. From this recent list now, for us who are from the field, we hear the undertones from the recent lists of the appointments. A number of proper servicemen who have, they call themselves career judicial officers. They felt that having served for all this while, they would wonder why they would be left out of the list. Now, that in itself creates in their minds the need to impress, or the need to submit. So some of them, they even submit voluntarily, that they are not being coerced into these things there, but they submit and they want to appease, the need to appease the state. What I think would be different with the other situation of if we appoint judges now on mission, they would have a mission really. It is for a given time. It's like a session that we have set you for a session, and we have said deal with 30 criminal cases, and at the end of 1 month, it is done. It is done. You will have limited interference, or minimal, or even none, because it is hard that you will find that someone is making calls over or to somebody who is there for a given cause. So if we would, for starters, as a country, arrive to or arrive at a point where we acknowledge that our law is supreme, and the judges and our bench also shake off the shackles of repression and shake off the shackles that are subduing them, and think independently, decide independently. Many of these issues here are drawn from the individual, that we can still have the same occur or have the same problem go on to occur, until the individuals, until we the Ugandans feel that indeed I am serving a cause bigger than either the state or a cause bigger than whoever is in my inbox trying to influence my decision.
You can ask.
Thank you, Eddie. If I could also just supplement your answer. Alfred, you see, at the moment, there is no independence in Backlog. Think about it. 45 trillion shillings, or even more now, tied up in the commercial court. The average time it takes a land dispute in this country is 5 to 7 years. Land is becoming a huge driver of crime, because the court is not able to dispose of land disputes in record time. What does that mean, that the court isn't able to dispose of land disputes? It means that a woman recently widowed, evicted by relatives or neighbors, running to a court of law, and then the court has to take 7 years. It means that the courts have become almost like a refuge in land matters for the people who are, for the scoundrel, for the people who are grabbing land, because they know that the court will, the wheels of justice will turn too slowly, and justice will grind itself into the ground. Meanwhile, they change the status quo, they move on. You look at criminal justice, what we've just been hearing of 5 years on remand, of a plea bargaining system where people are being held through a hostage situation, whether it is family law, criminal law, commercial law, land law. The civil division of the High Court is currently, I think some judges have been appointed, but I don't know if they've taken office yet. I think they'll be taking office soon, but has been sitting with one judge, hearing all civil cases in the Republic of Uganda. Even before the other colleagues in the court were promoted, that particular judge had a caseload of 700 cases. So we can't sit here and think that backlog does not represent a crisis to the independence of the judiciary, that backlog does not create a crisis to the administration of justice, that backlog does not create a crisis that requires us to think seriously. We were told on one of the spaces, as far back as 1974, there was backlog. So the thinking that is creating backlog, the thinking that created backlog and that caused backlog we must rethink the legal reforms that Eddie has spoken about, the computerization of our courts, the idea that there's a problem with the building of the Supreme Court, and the court can't sit for a year or two. For a whole year, there's not one single session of a court of law in this country, and that for 4 years or so, people's appeals haven't actually been heard or disposed of. The idea that courtroom is a building and not a service is something that needs to end yesterday. And these are the sort of conversations, Eddie, we're trying to have. I'm trying to get Humphrey on. We're trying to make sure that he also comes on and we can get his take on these subjects. But I think, Alfred, my contribution to that answer, I know I'm supposed to be asking questions with you, but my contribution to that answer is we value independence above everything. But we must also start looking at ideas on how to make sure that decisions are made. Now, will mission-based judges affect judicial independence? I think if we appoint the right people, I think there are enough people in this country who can sit down and hear a dispute. Whether it is a land matter, criminal matter, family matter, people are looking for a service. And we need to start thinking of judicial service as exactly that, a service. And once we have gotten that properly, then we can be able to deliver justice without fear, favor, malice, or ill will. Finally, on that point, I think we must remember we're rooting this whole thing in the law. It's rooted in Article 142.2, but it's also rooted in Article 28. A Ugandan appearing before the court has a right to a fair and speedy trial before an independent and impartial tribunal or court. In Uganda, we no longer talk about speedy. In fact, speedy is promised. Someone tells you, we'll have a speedy trial. You go to the commercial court, you say, I want an injunction. And they say, I'll hear you quickly. Speedy is now a promise. Speedy is supposed to be a right. Ugandans are not entitled to a slow trial. They are entitled to a speedy trial before an independent and impartial tribunal. And that's all we're asking for, that we need to start thinking about how to solve a problem that is taking on so many people, destroying lives. Last week, Eddie, we had some senior members of the bar here telling us the challenges that just women practitioners and women clients are facing just on account of backlog. And the challenges are real, the challenges are serious. The week before we had others, Alfred, it shocked me by telling me we've been having these conversations for 2 months. That's also backlog. Our judicial service elections should be happening now. But 2 months when people are talking about 5 years, maybe Maybe I don't know, but so for me, that's I think my take.
Thank you, Mr. Elson. I'm seeing some comments from the comment section, and I've seen people who have requested a microphone to speak. We understand we have been part of our audience for now 8 episodes. So this time we would want to be part of this conversation. You could ask your question. I'll start with the Nora Waraga. I hope I've pronounced your name right. You could unmute and ask your question or make your comment. Thank you.
We go back and they are not there. Okay, so 5 times you travel long distance, waste all of that time in court waiting for the judicial officer. The judicial officer is not there. Who handles that? Who handles that? And we are not talking one person. We are talking many people waiting for a judicial officer who is not there. And then the third one is actual function of the courts. You are in a courtroom and the advocates must speak very slow because the judge or the judicial officer has to take their own notes. How is that acceptable in this modern day? How is it acceptable? So we need to not say, oh, let's have more people who will be absent from station. Or let us not say, have more people of inferior quality. So my question to you guys, which institution in Uganda is responsible for holding judicial officers accountable and for vetting the judicial officers? And why don't we move to other jurisdictions, I hear, where judicial officers are vetted publicly so that by the time somebody is...
It is an honor to have you speak. Thank you, Nora, for giving us your views, and we are truly honored. And I think, first of all, the institution, Eddie will also take on the answer to that, but the institution, of course, is the Judicial Service Commission. The courts themselves as well should at least have mechanisms in which they handle an issue like that. And I think part of the problem you're expressing is a really serious problem of every time you're heading to court, if you're leaving, for those of us who are practicing from Kampala, you're driving, say, to Mbale. I'm not saying this is happening in Mbale. And every time you're on the way to court, you notice the car of the judicial officer passing you, going to Kampala. And that is a big problem. And that's the problem I think Eddie spoke about earlier, that judicial accountability. The Supreme Court, incidentally, I think years ago, gave a decision talking about independence and accountability of judicial officers. And we now need to really build onto these ideas, because you see, what we are trying to do by having these conversations is just to bring light into our judicial system, because our strongest belief is that light is the best disinfectant. Let us talk. Let us have these conversations. Let us open up these judicial conversations. The clients of the bar, like you, Nora, can give us the sort of feedback that we need to make sure that we're able to deliver the service that is required. Not just the legal service, but the judicial service that is required. That the courts are able, the courts and their officers, being us the lawyers, are able to deliver justice. But I think, Eddie, you should maybe take on the heart of Nora's question before we take another one.
Thank you, Ellison. I think, I don't know whether you're just speaking politely or politically. You need to tell people some of these things realistically. Quality of judges is a problem because of the nature of appointments. The JSC has locked their doors. You won't know what's going on. You won't know who is being considered. You won't even know what their track record is. You won't even know what they have done. Remember, even with the Radical New Bar, we get surprised when a list is shared, and you wonder, when did the vetting go on? We know about so and so a lot that we would have told you, and even when we have told of these faults, they are ignored, and you just wonder about the levels of impunity, disregard, and you wonder, where do we go to really? Now, my brother Elson will say, yes, something will be done, but ideally, why we've been discussing the radical surgery and the need for the elections of the JSC to happen yesterday is we need to break the walls where the JSC is sitting. Just break the walls. Let us see what is going on under the table. Let us see what is going on within those spaces there. Let us assess quality as members of the public, members of the bar. We know these people. We know their judgments. We know what they say. We know what they think. We know what they have written down. But when we are locked out, and that's why each one of us needs to join our rally to demand that the elections must happen for the JSC, ULS members, and demand that the courts must determine the matters where the ULS has been tied down up until now. Then about the absences, again, that also draws back to the JSA. Complaints are unaddressed. And the levels of impunity or indifference, they're just unbothered, less concerned. I think they just fall shy of saying, go to hell. When we complained and demanded that the JSC dispose the complaints against Justice Sekana by a given date, and we even called for a boycott of the court, the JSC just thought, you guys, go to hell. This is not your country, and that is where we are. That, we are all shocked. And until we get radically shocked is when we can begin to have meaningful solutions. About the court practice and something was mentioned about soft-spokenness and the kind of processes. Of course, with the enactment of the digital, I forget the exact SI, but we are trying to introduce digital means of hearing matters. That there'll be a microphone, or there'll be a system that maybe would even record to do with this having to write, having to delay trial because someone is taking every single note or even choosing what they will write. Now, under the Radical New Bar, we are moving towards digital transformation. We are pushing hard that we can indeed move away from the analog and become digital in the days to come. And maybe lastly, about absences. Some of the listeners on the page, Radical members, I don't want to mention their names, but recently there has been a public outcry about any judicial mishaps, that when a matter is coming up and the state isn't there, whoever is not sitting, the chief magistrate isn't sitting, word shall go around, and indeed it shall create a sense of embarrassment. Before it was being said to be a tax on the bench. But I think the public also must demand for their rights. That if at all they are bringing you for a bail hearing and the court has chosen to be absent, we can't be quiet about that. We must speak up about it. We must call out these persons, call them out and say, we know that you are on a holiday somewhere, but rights of individuals are being abused. Right now, we can't report them to the JSC, so we shall call them out and in our public spaces and call out their names where they are falling short and make these things come to light. I think those are ways of us beginning to, first of all, help ourselves before we get to the JSC election. When we get there and we are banging tables there, we shall have meaningful reform. But for now, let's call out. Let's call out those who are not delivering. Let's call out those who are absent. If there's a habit of courts don't sit on Monday and Friday because people are traveling back and forth, that shouldn't be happening. When you apply for a judicial job, it means you have sought to serve the country.
Yeah, thank you, Eddie. That's quite interesting. Let me get a question from Mr. James Semerera. I know you have had the chance to speak for quite a long time. We may have your question. Mr. James, are you able to speak? I think we can't have him. In the meantime, we can have from Mr. Mungadi. I hope I spelled your name right.
On the streets of America.
I hope I spelled your name right.
Yeah, you got it right. I hope I'll be able to speak because my network is shaky. I'm on the streets of America. Well, it's going to take you people who know the law to radicalize citizens. In America here, literally, we protest. I don't want to say we protest because I've become part of them. You'll find women who don't want to breastfeeding protesting. You'll find women who don't have men protesting. Literally everything is legislated. You go to hospital and the time wasted is accounted for by a lawyer, not even by your doctor. I got excited when Semakade came on the scene. But at the same time, I said, no, it's not Semakade alone. It's the revamping of institutions that coordinate with the Semakade. The law is not going to act alone, minus supportive institutions. You are talking about the land reforms, you are talking about, mention any nonsense in Uganda. It's because the citizens are just taking a ride in the back seat. That's where the citizens have to be in the gallery, the public. The American public gallery is filled every day, Planned Parenthood, whatever. You can't legislate something in America minus the law being mentioned to you. So as Ugandans, I think we need to wake up. You guys spend more time waking up citizens, radicalize citizens, not to pick arms, but to be able to understand that everything
Thank
is
you
law.
so much, Mr. Mungadi.
My network is bad, thank you.
Yeah, we are glad to have Mr. Isaac Semakada, the youngest president, on the call. He has been on the call since when we began this space. At this juncture, I think to follow some protocol, I will invite. I know Mr. Edis came as a speaker, but I would follow protocol and invite him to invite the president to speak to us. Mr. Now you're tuning in to invite as the secretary now, please invite our president to speak to us. Thank you.
Yes, thank you. Mr. President, whenever you pick a mic, everybody listens. Someone told me that what they admire most about you is you are courageous, and your courage will deliver even the most impossible situations. The speaker that spoke before said, let's wake up the country and radicalize citizens. no one is better placed to shake and break and wake up anybody than you. So I would invite you to share your thoughts on what we've been discussing today. Thank you. Than you. So I would invite you to share your thoughts on what we've been discussing today.
Mr. President, we can't hear you. Please, you may need this to unmute. Yeah, we can get you now. Yes, we can. Mr. President, we can't hear you. Please, you may need this to unmute. Yeah, we can get you now.
Council member, presiding on my behalf for our colleagues. Can you hear me now?
Yes, we can.
All right. I want to start by thanking my colleague in council, our interim secretary and council member, presiding on my behalf for our colleagues practicing all the way from beyond Mukono up to Soroti and Bukedi, all over what we call the eastern region, the eastern. But I am grateful for the tribute you gave to our conversations in the vortex of our campaign, the conversation that continued in council. But I felt I should provide some additional profile about you, Mr. Edinanguru. I'm happy you made it very clear to Mr. Karanga when he asked to understand who you are, what drives you, that you joined the bar even before you entered university. I was there, I saw it. You were our office messenger in the law firm of Mr. Navende and Madibo a long time ago. You hadn't even decided that you would do law, but here you are, and you are a sterling example of ambition, resilience, and patriotism. I was very edified when I saw you selected for these GSC conversations, and I should thank you for being able to fight back tears when you speak about such depressing conditions of legal practice. It's a testimony to your mettle as a leader, as a problem solver, and as a flag bearer for the Radical New Bar. You really have taken charge of the situation for yourself, for your family, for your colleagues, and for all donkeys at the bar who have all but given up and want us to remain in this swamp. You're a fighter, Mr. Nangu. It seeps through. And the topic says the future of legal practice. Legal practice will be left for very few titans like you. The rest will be mere statistics, but the actual practitioners will be people like you, Mr. Nanguru. And you must not really count on anybody else to save the situation. You should count on only yourselves, and you don't have to be many. So I wanted to, add that because I know you very well. I serve with you in council, and I'm very grateful that you have been a wonderful representative of the quality of talent we have in the Radical New Bar. I want to again thank Mr. Muyaka and Mr. Karuhanga for maintaining this consistent interaction about hard and annoying truth that we must confront if we are to get out of this level of awareness of the need for a collective conscience as the primary ingredient of any solutions, and awareness of a generational or cross-generational synergies as well is important. I am a very, very good friend and admirer of Mr. Elson Karhanga. I must confess that right from the word go. And I met you when probably, at the beginning of my career as well. And you're such a great listener. I'm not surprised that it continues. That shining streak of your character continues. You are listening.
We can hear a radical. We can hear a radical in the
From your
background.
colleagues, even
A
in the
rebel.
regions, even in the young bar, you bring these conversations to them. So I have a lot to say, but I have somebody who is policing me. We can hear a radical. We can hear a radical in the background. Yeah. So I am going to have to cut this off. I'm going to have to cut it short. But before I do, I want to challenge you, Mr. Karuhanga, and your colleagues to begin from the root, as we were challenged by my good friend and favorite intellectual alive, Miss Nora Waraga. Ultimately, I will speak to Backlog later if this thing continues, and I'm able to put my colleague. I'm able to provide some accountability here. But for now, I want to say that the only solution out of this, ultimately, is changing culture, both in legal practice and in judiciary. And the culture, the culture solution actually was contemplated and legislated in Article 142, Sub-Article 2, as Ellison says, and I'm glad that on this we have a meeting of minds, we have an intensity of passion. But we have a challenge, Mr. Karuhanga, which is not coming through. Article 142, Sub-Article 2 became the subject matter of great controversy right now because we have seen a second batch of judges appointed as acting judges, and literally they use the word acting, but really they mean judges on probation. They're not really acting judges. They are misdescribed as acting judges, but they are probationary judges. And a probationary judge, the notion of a probationary judge is not just unpopular, it is offensive to anybody that appreciates the role and place of a judge in a progressive constitutional democracy. Judges must not be under anybody's supervision. And with the way we know how probation works, but that's not the same thing as a judge on contract for a specific period of time and or a specific mission, as as senior counsel Karuhanga calls it. It's not the same thing, and that fine thread is not yet articulated. So we may have people who are here and they are still withholding their consent to this process because they see you as, they see Mr. Karuhanga and they see us as providing or manufacturing public consent for a repulsive idea as as a probationary judge. So we may be misunderstood as we are inviting our colleagues to back. I won't miss my words. These are really Nsumi Kambi, toxic judge lists that we keep seeing, and we've gone through such trauma with Judge Bukirwa's situation, and not just Judge Bukirwa. That's the most well known. Yesterday, the other day, my friend Quint Ojok jumped onto the space and surprised us with testimony that there's Judge Singiza, who has now been made chairperson of the Judicial Service Commission, was a probationary judge, I think, from 2022 until this year, and he made it a point to refuse to do certain cases. In fact, Quinto told us that the judge called them and spent very useful judicial time lambasting them for filing cases, placing before him a case, quote unquote, that will put him in trouble with power. Why did you bring this case? Why do you want me not to be approved? And he told them he won't give them a hearing date. So they were stuck for 1.5 years until they returned to the registrar and told the judge verbatim what the judge had told them in chambers. Like, this is where we are. So we are trying to move the whole nation to a new awareness, but we have an immediate challenge to confront. So these concepts, Mr. Karanga, we have to deal with. I don't know how you're going to manage, but we have an existential challenge. And in other words, we may fail, the conversations may not go anywhere if these conceptual challenges are not resolved immediately. I want to contribute here by inviting everybody to read the Kabumba case. Let me see if I have my... Yeah, it is called Constitutional Petition number 15 of 2022. The lead judgment was written by Justice Monica Mugenyi. Justice Monica Karijira Mugenyi. And at page 24 of that judgment, there is a paragraph called paragraph 63. Page 24, let's go there. Page 24, I think I'll take a screenshot and share. Page 24, paragraph 63. It reads, and I quote, it is inconceivable in my view that the framers of the Constitution contemplated having two parallel pathways for the first time appointment of judges. One under Article 142, Sub-Article 1, and subject to parliamentary approval, and the other under Article 142, Sub-Article 2, and not subject to such approval. Now, the operative word here is inconceivable. This is manifest error. The judge sees Article 142, Sub-Article 1 saying one thing, and Article 142, Sub-Article 2 saying a different thing, and she's saying no. The obvious thing is inconceivable. It is so fucking conceivable. That was the whole, the intent is clear. Under Article 142, Sub-Article 2, judges appointed under Article 142, Sub-Article 2 must go and face parliamentary vetting. judges appointed under Article 142, Sub-Article 2, face no such requirement. And there is good reason for that. I'm sorry, am I still audible?
You're very audible.
Yeah, I'm sorry. So for me, this is the first thing we need to explain, I think, as a ritual before we delve into the intestines of finding a final solution to backlog, if I can call it that, or a radical solution to backlog. Article 142, Sub-Article 2, Ellison, is your constitution near you there? Can you read it? Yeah, we're going. Can you read
Let me get it.
Yes.
Article.
It's still being looked for, but
No, just hold on.
but it says from my reading of it.
It's still being looked
But-
for, but
you guys, this is
but
the
also
problem.
from my recollection.
But anyway,
But
it is
that-
very simple. You can speak.
Article 142.2 of the Constitution of Uganda
it says from my
provides that.
Yes, you expand recollection.
but
I
but also from my recollection.
Yes.
Article 142 of the Constitution of Uganda.
Article 142.2 says that
It's really a very small line. It says
the president may
the president shall, with the recommendation of the Justice of a Judicial Service
it says the
Commission
president
and the
may
approval of Parliament,
acting on the advice of the Judicial Service Commission. The president. Okay, it says where the office of a justice of the Supreme Court, or a justice of appeal, or a judge of the High Court is vacant, or for any reason, a justice of the Supreme Court.
Okay, it says where
Yes.
the office of a justice of the Supreme Court, or a justice of appeal, or a judge
justice, the
of the
deputy
High
chief
Court
justice, the principal judge, the justice of the Supreme Court,
is
the
vacant.
justice of appeal, and the judge of the High Court shall be
or for any
appointed
reason,
by the president
justice
acting
of
on
the
the
Supreme
advice
Court.
of the Judicial Service
142.
Commission and with
Start
the
with Sub-Article 1.
approval of Parliament.
142.1 says the Chief Justice, the Deputy Chief Justice, the Principal Judge, the Justice of the Supreme Court, a Justice of Appeal, and the Judge of the High Court shall be appointed by the President acting on the advice of the Judicial Service Commission and with the approval of Parliament.
Yes. So when we come to very clear, and it has been the subject of judicial interpretation in Honorable Gerard Kafureka Karuhanga. It's a tripartite stage, starting with the recommendation of the Judicial Service Commission, and the Judicial Service Commission being a public body, it must process that recommendation based on principles of transparency, accountability, and so on and everything else. Then it sends these names. So the president can't be the originator. In the Karuhanga case, the president was the originator of names and asking for the opinion of the Justice of the Judicial Service Commission. They said, no, it can't. There's no reverse pathway. The names must only come from the Judicial Service Commission. If it gives you no names, you can't appoint. If it gives you one name, you have no choice. You can't say, I don't want. Okay? And so on and so forth. You send to Parliament. Your job is to send to Parliament. So it was a huge contest. That contest was so huge that it deprived us of a Chief Justice for 3 years. The president was all over at burials, weddings, everywhere he could get a microphone. He would say, the Chief Justice I want is Benjamin Odoki, who was clocked 70 years. And Chairperson Ogola and his committee and his commission were saying our Chief Justice is only and only Bat Katrev. And we will not, add you another name. And so we went without Chief Justice, and then we went without a Deputy Chief Justice as well, because the president said, I won't appoint anybody else. So, Mr. What's his name? There's a judge. No, there's a judge who was acting DCJ and became acting Justice Kavuma. Justice Kavuma, and it was an embarrassment. The bar had to boycott his attendance of the new address of the open new lawyer in 2014 or 2013, I believe. President Ruth Sebatindira had to lead us in a boycott and so we cannot go and be addressed by an imposter.
Who is hosting? Start again.
Let me buy. But it's still.
Don't buy. Use Wi-Fi.
We need to start.
Oh, but we are still online on YouTube, and where our space dropped on X. Alfred, you're getting us back on. But I think the important point which the president of the Law Society has been making in that space is that we need to push the idea of Article 142 and as you can see on that particular issue, as on many others, the ULS president is doctrinally perpendicular. He's clearly communicating to our listeners that the history of these provisions, and he was cut short in the middle of a massive historic moment where he was explaining the litigation of Article 142.1 and Article 142.2 of the Constitution. Now, for those who don't know, our Constitution provides for the appointment of judicial officers, and the appointment of those judicial officers is governed by two provisions of our Constitution. Article 142.1, which says that the President shall appoint with the approval of Parliament on the advice of the Judicial Service Commission. And in fact, there's a huge debate even in the Constituent Assembly. And those who have been listening to us frequently know that this is precisely what has been happening. Then Article 142.2 of the Constitution provides that where there's a vacancy in the court, or where for any reason a judge or a justice is unable to perform their duties, or where the business of the court so requires, the president can appoint on the advice of the Judicial Service Commission without actually going to Parliament. It's a quick fix solution. It is saying that where the business of the court so requires, people can go in and handle these issues. And the president of the Law Society was going through an explanation of this, and an explanation on which, as he said, him and I agree. Now, what his criticism seems to be is that we're not addressing what he calls the elephant in the room, the decision of the Constitutional Court in the Kabumba case, and that we're not going to get buy-in from some people because of a passage in a judgment. Now, in Kabumba's case, Kabumba was, for those who don't know again, Kabumba was challenging the appointment of acting judges. And as the president of the society has said, and which is a point we have been making, what they're talking about, what they're calling acting judges are probationary judges. And a judge on probation lacks independence. And the issue of the judge on probation lacking independence must not be used to throw the baby out with the bathwater.
I'm getting back soon.
And so that's where we are. So we're working through the technicality of what happened on X Spaces. As you all know, when Elon Musk was hosting Donald Trump, his own platform crashed. So I think there's this thing that happens when you're hosting some particular guys. The thing just crashes. Yeah,
it is back.
And now allow me to also welcome back our listeners on
You can join in. I don't know.
I don't see it. We're joining shortly.
Yeah, you can reshare. They will get on. Yes, so now I've made you a co-host.
Welcome back. Let me go. Welcome back, colleagues who have joined us. We had a slight technical glitch. As you know, historically, when Elon Musk hosted Donald Trump, the thing also crashed there. So it has also crashed here. And it has crashed here as points were being thrown about. Now, as we try to get back the ULS president and the audience, I think the point which was being made, which is a point that I think we need to address, is the issue of the distinction between Article 142.1 and Article 142.2 and the decision in the case of Musinje Kabumba. And so for those who don't know, Article 142.1 deals with the appointment of judicial officers, and I think the ULS president was making the case that that decision has been the subject of intense judicial comment and has been interpreted as a tripartite process. A clear reading of the language of the Constitution also shows it to be a tripartite process. But he also talked about Article 142.2. Now, what I want to do is maybe, just as he's coming on, just to give a brief understanding of the legal architecture, in my opinion. Article 142.1 sets out the terms upon which someone serves as a judicial officer. He's appointed by the president with the approval of parliament and on the advice of the Judicial Service Commission. The law is clear. The advice comes first, the president sends the names, and parliament approves them. Article 142.2 creates a different scenario. Within Article 142.2, there are three things that the framers of the Constitution had in mind. What happens when a judge is unable to perform his duties? What happens when the office of a particular judicial officer is vacant? What happens when the business of the court so requires? When their lordships, all of them sitting in office, are so overwhelmed by the business of the Court of Appeal, the Supreme Court, and the High Court. And the framers of our Constitution inserted a stopgap measure that in a situation where that happens, then the president may, on the advice of the Judicial Service Commission, appoint someone to come in a temporary position to act and solve that problem, that immediate problem. That problem being the absence of a judge, the office of a judge being vacant, or the business of the court so requiring. And our contention in all these spaces has been that the business of the court so requires. Now, the president of the Law Society was saying, what Isaac Semakade was saying, and I hope he'll join us soon. He was kicked off by technology. What he was saying was that if we read the decision in Kabumba, it's standing as a serious bar to the way we are moving on in this conversation, and that we're not able to get many colleagues to agree with us, and that we need to address the issue of whether or not it was inconceivable. And of course, he said it was conceivable. And indeed, it is conceivable. And not just conceivable, it's exactly what was conceived. Think about it. The framers of the Constitution gave us a way in which the bar can be deployed in good numbers to assist in the resolution of judicial disputes. But even in that deployment, in a deployment that would be mindful of the various challenges. And that's the debate we've been having here on these weekly spaces, which Alfred has reminded me have been 8 so far. And in that debate, we've been making the case that we are making today and that we have consistently made and that we're not going to stop making, which is that lawyers can act as temporary judicial officers. is that lawyers can be deployed where the business of the court so requires. And today, the business of the court so requires. 44 trillion shillings stuck in the commercial court. Thousands of people on remand pending trial for 4, 5, 6, 7, 1 year, 2 years, 9 months. The business of the court so requires that those cases are resolved, that the victims obtain justice, that the accused go free. Accusations cannot become convictions. We are saying the business of the court so requires. And so, Alfred, and I'm really happy to have joined and for this conversation. And I see the conversation has become big because this has precisely been the argument. And so the President of the Law Society has been making this case. Unfortunately, he has said he actually agrees with the position we have been pushing. It's the most logical position. It's the most reasonable position. It is a position that seeks to address a problem that exists. It's a solution that seeks to address challenges that are there. If we don't address these challenges, then injustice is going to be injustice everywhere. Because injustice is going to threaten the temple of justice. It means that the wheels of justice are going to crash. Just think about it. What do you have to do to get your case from the back of the line to the front of the line? If you're going into a courtroom where the judge has 1,000 cases, what do you have to do to make your case jump 1,000 other litigants? How does anyone think that Backlog does not encourage corruption in ways that are simply unimaginable? Fine, let's say you don't jump everyone. What then do you do? So you have corruption, you have incompetence, you have failure, and all of this is happening in a judiciary where judges are overburdened. I can't keep making this point. Where judges are overburdened. And so I am very happy to welcome all of you here to this wonderful, wonderful space. And we always have our spaces for a short time, but maybe we'll allow for some more questions from the audience again and see what people have to say about it as we try to get back some of the guests that we had. But remember, we're discussing the future of practice. And in my view, the future of practice must include practitioners being able to sit on the bench and go back into practice. This idea exists in the Constitution. We are not making it up. What we are proposing doesn't have to amend any law. It is there. Now, the comment, I think there's also the passage in the Constitutional Court judgment, which I think was Obita, that was cited, did not address really the actual provision of the Constitution. I'm told the President of the Law Society is back on, and you're back. Yes. The anti-backlog clause, where the business of the court where the state of the business of the court so requires. The passage in the Constitutional Court judgment, which I think was Obita, but we can read it again. That was cited. You know. Did not address really the actual provision of the Constitution. You know my brother, Mr. President, is a very eloquent speaker, so he speaks like these powerful church preachers who say, read 2 Corinthians. So, the Constitution of Uganda, Article 142 of the Constitution provides the anti-backlog clause. We are done 142.1 and 142.2. When the office of a justice of the Supreme Court or a justice of appeal or a judge of the High Court is vacant, a justice of the Supreme Court, a justice of appeal, or a judge of the High Court is for any reason unable to perform the functions of his office, or the Chief Justice advises the Judicial Service Commission that the state of the business in the Supreme Court, the Court of Appeal, or the High Court so requires. The emphasis, the state of the business so requires. The President may, acting on the advice of the Judicial Service Commission, appoint a person qualified for appointment as a justice of the Supreme Court or a justice of appeal or a judge of the High Court to act as such a justice or a judge, even though the person has attained the age prescribed for retirement in respect of that office.
President may,
That is the clear
acting on the advice of the Judicial Service
unambiguous language.
appoint
Mr.
a person
President,
qualified for appointment as a justice of the Supreme Court or a justice of appeal or a judge of the High Court to act as such a justice or a judge, even though the person has attained the age prescribed for retirement in respect of that office. That is the clear and unambiguous language. Mr. President, continue shooting.
So, under Article 142, that the framers were either victims of backlog in their time. They had the experience of a tyranny of judges and a tyranny of procedure, depriving you of having more judges, where you have backlog, and when you appeal to all those who have power, say the president, the Judicial Service Commission, everybody's answer is that, but the Constitution prevents me from giving you, a solution. So either that's the experience they came with, or they were foresighted. They said, wait a minute. The permanent and pensionable judges who Parliament approved may find themselves in the following situations. Number one, a vacancy, which may not be easy to fill for any number of reasons, because then the office of a judge is so important. They don't just feel it like you're feeling diesel, like refilling at a petrol station. No, the process is quite rigorous. So a vacancy in any of those three superior courts is a special thing, it's a special event. The second is an absence due to any reasons. It could be an extended illness. It could even be exile. I mean, the absence of Justice Kisache it's a shock. It's an embarrassment. It's a blight on our conscience as a nation. But there it is. We have an absence. We also have an absence, which I have condemned before, but you don't join me. DPP Apodo absconded. She absconded. She's a judge of the High Court in the criminal division. That's how the records of the judiciary show her. She absconded. She's now moonlighting DPP's office. She's moonlighting on behalf of the executive as a prosecutor. Official function. Parliament approved her as a judge for life. So there you see a politically instigated, orchestrated, supported absence. There are many others of that kind. Judges are usually absent. They can be summoned. They can be invited to lead commissions of inquiry. They can be invited they can be invited on request by other nations to help them. And Uganda, as a member of these international treaties, may not say no. We have many of those kinds. We have Justice Sebutinde. She's a judge of the High Court of Uganda. But she's been so absent, serving on international tour. Justice Bosa is absent. She's a judge of the Court of Appeal. There are others. There were notable absences that we speak of: the absence of Justice Egon Nantende in Seychelles, in East Timor. There were absences of Justice Kaswaga in Seychelles as well. You know, they bring prestige to Uganda. So absences, that clause also envisages emergencies that we can't even imagine or think of now. It envisages the people who wrote the constitution that they were able to envisage a pandemic. A pandemic can wipe out your judiciary. It can debilitate your judiciary. You know, it can. All judges can go in the conference and infect themselves. So there has to be a safety, valve, and that's it. This is a constitution. Extraordinary events. The most urgent one that we are discussing is backlog. And it was intentional that for the judges who will be appointed under Article 142 sub Article 2, number one, it is clear on the face of the clause that they will be on a contract. There is no mention in sub Article 1. These will be on a contract for a specified time. These will be on invitation. The Chief Justice has deemed it to instigate a recruitment, what Mr. Karan calls the mission-based recruitment. I must provide accountability. This was a clause for the Chief Justice. Samakade is calling him all sorts of names. My professional colleagues who I lead are asking for solutions through me. And I have told them their solutions are in the law. But Justice Dolo is different from Justice Odoki. Justice Odoki invoked Article 142 sub Article 2 without banging the table. For Dolo, we must bang the table. I banged the table in two articles. The first one I said, why are Supreme Court judges earning money for free? Because this man Dolo closed the Supreme Court for 7 months. 2.1 was taken as wages for judges who were sitting at home doing nothing. Apparently because he had seen a rat and some sparks in the same office. Justice Katwebe had been there. Justice Katwebe had seen the same rats. He had seen falling debris. He had served like the good Catholic he is. That building color was always unsafe and unfit for purpose. But I don't know. This judge has served in it without being pussies. This one sees a rat and then says, I must close the court. And closes the court and just does nothing. And the bar was quiet. I banged the table. The next week they said, oh, we have found premises. But it was December. What's the point of entering premises on 1st December? Anyway, I thought they would be serious. They did nothing. They went in conferences up to April until I had to write another article and say, are with you. And I showed the theft or the mismanagement. This time I wasn't blaming everyone in the Supreme Court. I had received some feedback that Isaac, all power in the Supreme Court by Rule 20 of the Supreme Court rules is left for the Chief Justice alone. The Chief Justice is the sole decider of what case gets heard when and by whom. So judges in the Supreme Court, however eager they want to work, they can't assign themselves work. So I had to change and say the backstop to the Chief Justice. And first duty station at the bar was as a clerk to Justice Katrevi in Mengo. 5 justices. One of them, the Chief Justice, used to in Kampala. In Article 131, administrative functions. But he would report when the court administrator has, put up a session or there's a case or there's a discussion. He would turn up as any, as a judge, perform the judicial functions. Justice Mulenga was also absent for most of the time because he had international duty. I think he was a judge in the East African Court of Justice, which was starting, and it had to be given special care and attention. He also had a stint in the African Court of Human Rights. So we only had Justice Katwe, Justice Sekoko, and Justice Katwe, Justice Kanye Hamba. 3. They were the ones, in fact, those of us who came for clerkship then were asked by then the registrar, now my Lady Justice Uolayo Henrietta, to select any of those 3 for supervision. And I said, but this is a court which must have 3. So during the 8 months I was there, I saw a civil session, a criminal session, and 2 constitutional sessions. How did Chief Justice Katrewe do it? He invoked Article 142 and he invited the judges into the Supreme Court to get business moving. That is how Brigadier Henry Tumukunde, and so the case being argued, was able to argue a case. Nearly 3 judges in that case were acting justices under 142, and so on and so forth. Now, the problem we have is that in living memory, the only Chief Justice that has invoked Article 142 has been Chief Justice Odoki. And Chief Justice Odoki used to invite sitting judges from the lower court or high court. I remember I saw Justice Gola Broad. I remember I saw the deceased Justice Constance Chuma, Christine. I saw all these people coming from, and of course, you can forget the case where also Justice Egonda as well. So, and when Chief Justice Odoki and his ex retired, they used to come at age almost at the same time. Chief Justice Katrewe then, who had now occupied office in 2015, you see, because of that wrangling between 2013 and 2015, the Supreme Court suffered vacancies again. So even wrangling can cause vacancies, political wrangling affecting the judiciary. So what did Katrewe do? He said, wait a minute, Parliament will take too long to give me good quality judges for the Supreme Court. He wrote a commission to cause the president to retain 4 justices who had clocked retirement age to continue working for 2 years, as the process of happen. Now that history is what Justice Monica Mujenyi is telling us, that 142 is closed for only serving or retired justices. This is important. Why I really called in Mr. Karuhanga. I called in to say that there is a culture of ring fencing. There is a culture of cliquism. I don't know where these judges get it from. Once they become judges, they want to be cloistered, like the old English judges of the 13th, 16th century. So they don't think that anybody else should have access to their bench to just do the job. They don't see this work as just work. It's just work. At the end of the day, you are a judicial worker. So you are Staronyo. You are a judicial worker. So, but for them, they prize procedures, prize prestige, they prize perks over principle. They prize power. Want anybody inside that power chamber. So they treat the entire judiciary as some form of old Victorian, star chamber. You are the one who went to Kent. You understand what I mean by that. Others don't. So this mululu for judiciary, tribalism, which we must abolish, by the way, create it. It says, including any who would have retired. The president, the choice is broad. The choice for the chief justice, the choice for the president is broad. Is anybody qualified to be a judge of the High Court, Supreme Court, should be able to, to fill in and perform a patriotic duty. This selfless task of listening to people's problems and offering them solutions in their lifetime. Why do you say it's only for I wanted to speak to that issue. One of the big is culture. There's culture at the bar. We shall discuss that another. We are discussing what cultural conditions these and why would a judge think they can be for 5 months? It's because we have the culture. He was calling it devil worshipping. We are trapped in the culture of. Forgive me, Ellison. This is your space. I am trying to control what I would use, but somebody has been absconding, and they are because they know their colleagues will permit them. Okay. There is, you see, they don't have a culture of accountability within themselves, and they don't want any anyway. Let me stop here. I have been called to stop, but I can continue. But I think for me,
I can see you have a rebel in the background.
yeah, the rebel is the first thing is right. So, colleagues, let me maybe interfere and finish paragraph 63. Paragraph 63 is a lady says that the difference between 142 and 1 it was an error. Let me resolve as follows. She continues. The more purposive interpretations, my opinion, the more purposive interpretation of those constitutional provisions would be that the option of appointing as acting judges under Article 142, Sub-Article 2 would be exclusive to serving all retired judges that would have already been subjected to parliamentary approval under Article 142, Sub-Article 1. Nonsense! We're talking about judges have suffered a terrorism attack. People wait for traditional formalities.
Have we lost him?
Recruitment, all appointment of judges would be subject to parliamentary approval under Article 142, Sub-Article 1 of the Constitution, and thus confer substantive appointments upon the appointment. It is conflicting two different ideals. Article 142, Sub-Article 1 is a pathway for the permanent and pensionable. Article 142 is a pathway for the temporary and non-pensionable. Those who are not obsessed with being called my lord. Table bangers who just want to get the job done. This is not unusual. Within our own rules. of practice as attorneys. There's a rule. Rule 3 requires us to handle the case of the client personally to completion. But again, Rule 3 says, as an exception, to handle any part of your brief. Thanks. But existing adjournment, you may not involve the client in making that decision. Kakarana, you're familiar with this, you're a litigator, right? Hello?
We can hear you.
Yes, are you familiar with what I'm talking about?
Yes.
Yeah? Our own rules of professional conduct. Hmm? They would be nice to read. There's rule 3 and I think there's like rule 9 or 11. Eh? A lawyer shall not interfere in the brief of another. However, on invitation with certain, rituals performed, right?
Yes.
So, what's unusual? Why don't judges want assistants, deputies, auxiliary? They're not just, you should hear their judicial conferences. They call us hooligans, like, every dirty word you can imagine. That's what they. So for me, that's the most important thing to start with. The radical stance, because for people who should be senior, people who should know history, people that they are drunkards, they don't even write. How can Kanyahamba be the sole person on the page writing books about Uganda's history? And when they write nonsense as if they are pastors. Let me stop there. You can continue.
Okay, so let's go on next meal. Okay. Thank you very much to the president of the Uganda Law Society, as usual, in his usual characteristic and eloquent style, firing on all cylinders. Clearly in need of mission-based judges and strongly in support. I think there are serious points which have been made. And maybe I'll invite either Alfred or Eddie to continue. And then we'll start winding up very soon. But I think there are serious points which have been made. Ultimately, what we are dealing with, and I agree, is a problem of culture. But I think it's a problem of culture that even predates. I know Eddie likes saying that I'm cautious and sound political, but I think it's a problem of culture that even predates. If you think about the 1967 Constitution, the 1967 Constitution had the Chief Justice as the chairperson of the Judicial Service Commission. The 1967 Constitution had, I think, the Attorney General as a member, and then the President appointed others. The culture of the 1967 Constitution, which was a culture of absolute executive authority, almost absolute presidential power. When you look at the 1967 Constitution and the judiciary of the 1967 Constitution, the Chief Justice was appointing, the Chief Justice was really in full control of the judiciary. And then in 1995, the framers of the Constitution, the first thing they did is they removed the Chief Justice from the Judicial Service Commission. They said, yes, the judiciary can be represented and must be represented, but so must the bar. On top of that, the Public Service Commission. On top of that, we must introduce new measures in which we are getting the idea of the 1967 Constitution, of the 1995 Constitution, the fundamental revolutionary idea of that Constitution was that the 1995 Constitution created an idea that judicial power is derived from the people and must be exercised in accordance with the wishes, norms, and aspirations of the people. The problem we have been having is there's still a lot of 1967 thinking in a 1995 constitutional dispensation. That is why if you look at the judicial service rules of 2000, I believe 5 or 7, you will realize that the judicial service rules are actually rules for the 1967 constitution. I invite anyone to actually go and read the rules the Judicial Service Commission wrote for themselves 10 years after the making of the Constitution, or 12 years. And you read those rules and realize that they're actually enforcing the provisions of the 1967 Constitution. Where the framers removed the Chief Justice from the JSC as a director of the JSC, the rules tried to actually bring him back. So the cultural problem is actually a long-term cultural problem, and the release long-term cultural problem is 67 thinking in a 1995 era in a 2025 generation. And the whole thing is not fitting. And it's not fitting because it's not thinking properly. Just think about the idea of digitization, of making sure that you can deploy technology in the resolution of disputes. Just think, I mean, people come to court and they just wonder what the hell we're doing. So many people come, you saw Mr. Waraga here earlier, just wondering, what the hell are you guys doing? Because we are running a 1967 system in a 2025 dispensation. And the beauty about these sort of debates is us a chance to help broaden our thinking and realize that, you know what, if you know, there's so much that the 142.2 actually brings. It brings an expertise from the bar that may not sometimes be available on the bench. It brings I mean, we have lawyers right now. I've gone around and seen, we have lawyers right now, senior lawyers sitting up country and all over the country, senior people, retired people from the office of the DPP, retired people from the AG's chambers, just recently retired, who can actually sit down and render this service with the experience that they bring. We've got lawyers with incredible experience in IP, in oil, in technology law, in criminal justice, just sitting down there practicing. Yet the law allows their skills to be deployed for the benefit of all Ugandans and for a period of time. And that's why we're having these conversations. We're very happy that we've had the president, we've had you, Isaac, on this space, really supporting this idea and supporting it with a broad historical and deep analysis of where we are. And of course, in your usual bombastic and flamboyant style. And the point which really needs to sink in is what is wrong. The same judges you're going to appoint, going to appoint them from the bar. What then is wrong with getting in, solving the problem, and going back out? That for me is the thinking which we need to encourage. I think we can have maybe one or two other comments from someone who wants to have this, and then maybe a wind up from Eddie, and I don't know if Isaac is still there or he's been engrossed by the rebel, or Alfred. I'm not seeing Mercy back on. For those who are just joining us, for the last 8 weeks, we've been having discussions on X Spaces on Article 142.2 of the Constitution. And Article 142.2 of the Constitution provides that where there is a vacancy in the court, where there is, where for any reason a judicial officer, that is a justice of the Supreme Court, Court of Appeal, or judge of the High Court, are unable to perform their functions, or where the Chief Justice informs the Judicial Service Commission that the state of the business of the courts so require, the President may appoint lawyers in temporary positions as judicial officers. Not just lawyers, but lawyers and retired judges. Anyone qualified for appointment. And what we are saying is that this provision of the Constitution allows for lawyers or whoever is qualified to be appointed as a judicial officer to get in, solve a problem, and get out. And we had a guest here, and maybe we'll also try and share the link, from South Africa, who told us this is precisely what happens in South Africa. And in South Africa, if a criminal case takes 9 months from plea to decision, that's called backlog. If a case takes, I think, 6 months from the filing of the last pleadings to a decision, that's called backlog. In Uganda, if a case takes 6 months from the filing of the pleading to the decision, that is prima facie evidence of corruption. People will say, how the hell have you been able to get your case heard so fast? I am in a case where Someone asked me, how come your case has moved so fast? We have been hearing our case for the better part of 2 years. And that's the idea of speed. So, speed, justice, the Ugandans are entitled to a fair hearing before an independent and impartial tribunal, but the Constitution says to a fair and speedy trial. What we are trying to have, the discussions we are trying to do is to bring to life what was the most forward thinking can't be in 1995 when we are in 2025. I think that is really our contention. So I'll allow for Alfred to go back to hosting the space. Alfred, as you all know, is our designated host and one of the big thinkers. Alfred, I've spoken enough. Let me hand back to you.
Yes, thank you so much, Mr. Sunan, Mr. President. I think from what Mr. President has said, briefly, I think there is a process debacle in the appointment of judges under Article 142.1 and Article 142, Sub-Article 2. And I think we dealt with that in, I think, episode 4. You may follow it up on the conversation, but you may bring it up someday. And then you hinted that we are in 1967 thinking in a 2025 dispensation of justice. And I think that brings me to one question which I've been pondering on here, which I want to ask Mr. Eddy. Do you think now the current legal education curriculum adequately prepares lawyers as of now to deal with the challenges posed by case backlog? Because you have presented them, you haven't presented a solution, but then is the legal curriculum still preparing them to address this challenge of case backlog? Thank you.
Okay. I think we have just we're still the president's emotions. And you see, his voice for me speaks volumes, but it speaks also about our own frustrations in the system, the burdens that we bear. Now, he can raise his voice as loud as that just to express how he feels within himself. I want to just say, before even I come to what you're asking, I want to just not let some points be lost. The egos on the bench, he called it devil worshipping, that we are hidden behind decorum and we are obliging, my lord, most obliged for a baseless decision. We are obliging for bad decisions. These are some of the things that we need to start to address even before we walk the journey with Edison now. He's giving us, he's pointing us to a future that we indeed are aspiring to. But today and now, I would invite the members of the bar to rally behind the radical new bar and bang the table. Let's bang the table. The table can't be banged by an individual. The bar needs to rise up and bang the table collectively. Bang the tables at the courts. Bang the tables at every other office where that is impeding justice. We are struggling as hard as we can to begin to bang the table at the JSC. And I know we shall succeed. We shall succeed. Because these gods of our day need to be shaken and thrown off those higher and mighty stools that they are sitting. Let them serve their servants.
Yeah, maybe just before you go out from that point and even get to answer my question, I had one question from the audience because you're talking of banging tables. Someone was asking, what do you mean by radically shock? Like, you explain further, radically shock the system, the judiciary, what are we radically shocking and what do you mean by radically shock? I think it aligns with what you are trying to solve, banging the tables.
I think what I meant to say is we as a country must be shocked by what is going on. We must be, you see, until you're shocked by a situation, you can't rise to action. Until it affects you. Most of the time we feel we are withdrawn and we're indifferent because it is not me. Right now, any of us can be in Kizza Besigye's shoes. Any of us can be in the shoes of the Kalamajongs who now can't obtain freedom because they are sitting in their hands with the Supreme Court judgment that is ineffective on their part. The DPP is unbothered. She's unbothered about their plight. We have Kiza Aaron, who was struggling to have a date for his matter. And when he gets a hearing date, the matter is dismissed on procedure. You must really be shocked. Something is really, really, I even wonder how we're able to practice, how we even are able to sleep at night. How do we sleep when our own Aaron is, he's detained on no charge. He's detained on no case. How does even the prisons hold him? In a different system, he would be holding the prisons liable for illegal detention. But now we are all going about business as normal until we are shocked by these things here, until we are shocked by Kisache's situation, until we are shocked by Justice Bukirwa's situation, until we are shocked by these things. Because you see, even justice, even the bench themselves, even the bench are also unbothered about the plight of their own. When they suffer misfortune, when Bukira was, Haloji Bukira was unable to serve, nobody even came out to address her plight. And when we were asked about the situation, we were told, tread carefully over that issue there. Why is this the case? Why must even this be the case? So until you get shocked, Alfred, we can never rise to action. We must rise. The beauty is we have a president who is able to rally, and for him, he draws his fire from his own experiences. That he said he wants to pour a fire, and the fire is either going to cook or burn. And we must rise to those levels. We're either saying, yes, we are presenting fire, and each of us is carrying the same fire. Not one of us or some of us. It must be all of us.
Yes. Now, thank you, Eddie. I think that one makes me, I want to read one of the comments from the space. Someone is saying, we must challenge ourselves and challenge society to get out of their comfort and personally participate in getting solutions for the things that make life not as comfortable as we desire and deserve. I think that's the reality of we must rally and wake up. And someone was saying the backlog is mainly because of the slow dissemination of justice, coupled with sanctioning of case files by the DPP when cases are not contacted yet. People still remand for years, equal their sentence if not, or if convicted. Someone just appreciating us for the discussion. Then we had Abina Nambara saying the respect for service is lacking in the judiciary. The Officers Commission is not monitoring their presence at their station. I think it's because now we don't have our candidates in the Service Commission. We've been now monitoring them close to close. But we have been a wonderful audience since 7 p.m. It's getting to 10 p.m. I think at this juncture, we'll have the parting shots from Mr. Eddie. Then the lawyer will close his space with his parting shots. Thank you.
Okay, in my final remarks, so much has been said about reform, but that reform. Okay, wait. Okay, in my parting remarks, so much has been said about reform. So much has been said about the face of how we enjoy our rights. But none of that is going to come to us on a silver platter. None of that is going to be served to us. None of that is going to just come to us as we expect. We must bang the table. We must bang the table. We must bang the table. And that is how I would want to even end on that note. Bang the table wherever you are. Bang the table, for that is the only way we are going to wake up our institutions, wake up our country, and get us back on course to serving our citizens. Thank you so much.
Thank you, Eddie, for your parting shots. Mr. Semakade is still on call, and before I call on Helson to close the space, I request him to have his parting shots so that we have those shots until the next week on Wednesday for our episode 9. I hope what episode 10 will have like a sort of a party. That will be like celebrating 10 years of this episode. But yes, because I think each episode is like yeah. But now, let me have Mr. Semakad have his parting shots before Mr. Nelson comes on to close the space. Kansuk, are you on? Yes, I can. You may proceed.
Reaching, having is radical. This is the appropriate use of digital transformation to create community, solidarity, and the true role of the in a post-colony to help us midwife out of a colonial contraption. So to get Ugandans who would otherwise be watching pornography, comedy and other stupid things to in conversations about democratic institutions, it must be celebrated if it can enter double digits, sir. So we insist on a mega fest. Speak of it as an option. That's to compliment my good friend Son Karanga when he says we are stuck. Judicial culture in Uganda is stuck. We are not stuck. It's not stuck. It is part of the effort to get you unstuck. But the judicial culture in this country, the legal culture in this country is stuck. In 1967, I just wanted to give flesh to that picture because those who have not been appropriately introduced to constitutional history may not understand. By 1967, there were no Ugandans in the superior court. They were all foreigners. The most to do then was to Africanize the bench, to move away from, English judges, Indian judges, Pakistani judges, and bring on Nigerians, Ghanaians. I think it was the sublime intellectual Abu Kacha Mayanja who asked that what does the government have against Uganda? Because qualified Ugandans were existing. They were in politics. They were elsewhere. But government could not consider it, the independent government, the idea of giving judicial office to Uganda. Now, so that created a culture of its, a cultural dynamic of its own. An us versus them dynamic. Now, that's the dynamic I think Mr. Karuhanga is talking about. But now, almost the bar has Ugandans, we hope. But there's still an us versus them dynamic. And it seeps through their jurisprudence. And it's responsible for your diminishing revenues at the bar. It's responsible for the apathy you see within the bar. It's responsible for the decline at the bar. It's responsible for the overall anger, ever increasing anger that the public has against the legal system as a whole. Because for them, they don't make a distinction. They see lawyers as, deal makers, judges, deal makers purely. So we share faults with these dinosaurs. Some of you may have fantastic cars, EVs. Edison is going to move into a new office very soon top of the range, but we are stuck. And I like that he can reconcile the contradiction. His law firm, Kampala Associate Advocates, is doing all it can to move into the future of legal practice, as our topic says. But it must face the embarrassing, disconcerting reality of having to present submissions, to present on behalf of clients in a judiciary that wants to remain stuck in 1967. The only reason that some of us unite interests with Mr. Eson Karuhanga is simply because he acknowledges and accepts this embarrassment. He accepts that it affects us together. He accepts that although he may be a child of some fortune, he knows that if things were better, we would all have an equal chance to make something of ourselves, our lives, and our careers, as his dad did. Because his dad has a fantastic story, of rising from ashes. People don't know this. I was lucky to get introduced into this story when I was still a student. And when I worked with Justice Katrebe, because Justice Katrebe had been a partner at K, and we were together now in chambers at the court, and we could discuss chamber times. He had so much respect for Mr. Karuhanga, because I asked him point blank, tell me without explanations, why did you leave legal practice to choose to come to the judiciary? The man was earning 5 million shillings. As to why? Who does that? This is, 9 million shillings. I was like, who does that? Why? Is it because Mr. Karuhanga was a bad man? He says, no, actually. Without him, there would be no law firm. He understands practice, the future of practice. So that helped me understand, oh, wait a minute. There are lawyers that have always been futuristic. It's these lawyers that set the high water mark for the rest of us. Lawyers like Dr. Eddie Karanga, they set the high water mark for the rest of us. I had seen Dr. Eddie Karanga, the first time I'd met him, he had come to speak to us in St. Mary's College, Kisubi, through his Africa Leadership Institute, something they had started. Some think tank to promote values of liberal democracy and everything, and give us hope that we can actually meaningfully create a generation that can prioritize principle over power. That things like the new constitution, democratic institutions, were truly people's institutions. I think that was the idea. I think the most animated way of bringing this home was through a scorecard they did at Parliament. And it was very exciting, because then people understood what Parliament does and what their MP does and so on. But it made him very unpopular, and they had to stop it. So I was very interested in see this lawyer who could quit Parliament and critique Parliament and check Parliament, and then come and even challenge the bar. His own partner. So it is not by mistake, and we should not apologize for having different ideas. And being impatient, sorry. We shouldn't apologize for being impatient for good. In fact, here we're not calling for reform. We are calling for implementation of what was promised us. I as the leader of the bar now, I unite interest with Mr. Karuhanga in no uncertain terms, because I am fighting for jobs for many lawyers, not just jobs for the sake of making money. I'm fighting for the survival, salvation of the bar and legal practice of the future. We can't be held to ransom by the seconds swallowed. There has to be a rule, like we were told in South Africa. In South Africa, they even removed we were told, Alf, you remember, Benjamin told us that for them, they amended the interim constitution. So the final constitution, the appointing of acting judges, ad hoc judges, temporary judges, doesn't even reach the Judicial Service Commission. Did he say that? He read the section 175, he said. Me here. Yes. He said it doesn't. The Judicial Service Commission is involved. For the, assist me judges, it is the head of division, head of circuit, who writes directly to the Minister of Justice that I have a situation in my division. I have a situation of backlog in my circuit, which I need to resolve quickly. So there is a roster, a judicial roster for advocates. These things are not very distant from us. These people who like England and English law don't even care to understand the transformation of English law and English culture. Because if anybody reads Bailey, that's the what's Bailey? British and Irish Law Information Institute, they are Yuli. You would see that so many of the judgments, especially in their commercial court, they are commercial court. It's a commercial court.
It's a commercial court, yeah.
Yes. The bulk of judgments are written by temporary judges. They are QCs. Cs now. Such that, we have a case. We have the Sudil case. I would like at some point I talk about it so that I show people data, because Ugandans like thinking that they know everything. They don't want to learn anything. The only time they want to, they must be forced to learn. I think because someone once said it's because because of the education system where they have to be beaten to learn, abused to learn, insulted to learn. They can't voluntarily, in a think tank, in a think space, learn. They come with this attitude of, since I know English, I know everything. But this is how England has been able to maintain its major source of foreign exchange, law and justice. Many contracts declare the laws of England and the High Court of England under the supervision of English law, meaning that they can see these matters can still go to an English judge. Why? So England, how has England managed this? We should copy and ask them ourselves. We could also be the New England, where people declare, no, I must go and be before a Ugandan judge. Those judges don't. So I thank you, Ellison, for giving us this opportunity. I condemn you a little for not being repetitive. in propagating the solution under Article 142 sub Article 2. Because we've had some spaces in the last 2 weeks when I had some time. The point I have made is that we are our worst enemies. Very many lawyers with whom we practice law no longer believe in principle. They don't like the fineness of principle. They don't defend it. They don't nourish it. The late Tamari Mirundi said it better. We don't. Those are people who read the raw materials, not law materials. This is it's the proof of the pudding is in the eating. So we ourselves have become addicted to power. We negotiate and transact and bargain and do our dispute resolution, counting on power and might instead of principles and rights. We brag about power. I have my Gambano. What do they call it? Huh? Gambano. I forget the word. But that's it. It's a very important. Yes, it's a very important lexicon. Gambano is not limited to the marketplace. It has entered the legal system too. And some people are so scared when we say Article 142 sub Article 2. The real worry for them is that Gambano will be too much. Are you getting me, Esther? And we have to be honest with them and say, yes, things shall get bad and worse before we get better. That's it. That's the only way nations have arrived to the shining castle. Things have to get so much bad. And at Radical New Bar, we are intent on putting out the fire. It's yours to use. It either burns you or you cook with it. But for us, we are force multipliers. We are energy generators. We signed out of Umeme long before Umeme handed over power to UDCL. We found our power. We encourage all of you to do the same. There is so much power in this thing Mr. Karuhanga is saying. Advocates who have practiced, for more than 10, 15, 20 years with some ethical fidelity, with demonstrable doctrinal fidelity, should be able to step in, on invitation by head of division even. We don't even need a Chief Justice. We should be talking about amending Article 142 sub Article 2 to give the power not to the Chief Justice but to heads of divisions, as they do in South Africa. This is what we should be talking about now. But because the thing has been there like a museum piece, we have never used it. Many advocates, many judges on call are seeing it for the first time. In fact, when it came up for interpretation, the whole court got it wrong by 4-1. Now it's before Supreme Court, and we don't know how they will rule. If we don't keep discussing it from the root, they might also rule badly and lock us out. Could the Constitutional Court of Uganda lock out lawyers from a constitutional property they're entitled to, and the bar doesn't rise up in arms? Well, I wasn't president then, I'm president now, and we shall rise up in arms. Paragraph 62 and 63 in the lead judgment of Justice Mujeni in the Constitutional Court case of Kabumba must be clarified in the way we are advocating for here in the Karuhanga spaces. I beg to submit.
Thank you so much, Mr. President. From your take, I see the major source of foreign exchange in England is land justice. So I'm already imagining a Uganda where we have also land justice as the major source of foreign exchange. I'm having some little comments I want to pass before I call on Mr. Karuhanga to finalize with the space. Mr. Lula has said Also in Masaka, they're having a problem of case backlog. There's a problem at Masaka High Court. There's only one judge who has replaced one of the two judges pending return from the one on study leave, and it's very shocking. I think when we had Mr. Shewa from Masaka one time, he mentioned this. Then there is one Misaka Saga who said thanks for always teaching the law. Then there is Salim, he's saying because of case backlog, courts are like window markets full of clients. And with that, I will call him also improve. Thank you.
Alfred, thank you so much, Eddie, for the time you've given us and for your thoughts. Thank you so much, Isaac, President of the Uganda Law Society, President Isaac Semakade, for your very kind and generous words. I also am sure that I speak for Dr. Eli Karahanga, who I saw on the space earlier. I don't know if he's still on, and I am sure I speak for him to say thank you very much for those very kind and generous words. I think the point has been made, and I couldn't make it more eloquently than the president of the Law Society has just made it. The Article 142 is constitutional property that was given to the bar. It is a constitutional check upon which the citizens of this country can be able to bank that there shall be no backlog. And as one American once said, we cannot accept the notion that the bank of justice is bankrupt. And Article 142.2, this constitutional property for the bar, allows the bar to continue serving the wider public. So I don't think that anything more that I can say can really help to express my agreement on this point. And I think I'm also very grateful to everybody who's joined us. And I think, as according to Alfred's rules, we shall certainly be closing. I think this is probably one of our most attended spaces. I'm sure it is because of the presence of the president of the Law Society, who is in his own right a serious and leading thinker on these issues, and also because of the presence of Eddie, who is also in his own right a serious and leading thinker on these issues. And for us, we are really honored and privileged. I'm sure I also speak for Alfred when I say this, and for Mercy Chemutai, who was on earlier, but I don't know what has happened to her now. And for Elaine, who I also saw on earlier, but I don't see her now. I don't know if she still is on. What we've been trying to do in these conversations is we've been trying to bring the light, because light is the best disinfectant. We have a constitutional provision that is there. Can we enforce it? This constitutional provision has these opportunities. Can they be availed? I think that's the main point. But for everybody who has joined us, we are very grateful to you. I think it's now time for us to close the space and wind up.
At the risk of being bad-mannered.
Yes. I don't know if I can hear you. You've slowed us down. Hello? Can we hear? Can you all hear me?
Edison?
Yes.
Yes, we can hear you.
I thought technology had slowed me down.
At the risk of sounding, at the risk of being immodest or bad-mannered, ill-mannered, I would like to intervene,
Yes.
But doing it to you as you have been doing it to witnesses of the state. That to have good sleep. When we come to your space and we show you the root and heart of the matter, and you don't show us a direction, what are you going to do about paragraph 62 and 63? in the lead judgment of the Constitutional Court in constitutional petition number, is it 16 of 2023, which could easily be affirmed. And then we shall be practicing in the graveyard while the rest of the world moves on. Are you getting me, Elson? What is your anger? Legal ingenuity that is highly paid for. Promise us that you're going to do something. You're not just talking. Do you have to first be elected to do something? This is my my credo. This is my from the heart. Yes,
He promises to do something even if he's elected. So being elected will be just an addition to doing what he's going to do.
No. This is an existential threat.
Okay, let him speak for himself.
We can't be a dead bar. We have been that. Okay? Everyone knows the rules of this country. Uganda State House is open for business. We want leaders, when they emerge, to lead us, whether they're elected or not. Just like his father. Edison's father began the tradition of calling it quits and leaving parliament before the post-flee. Edison?
Yes?
Hello?
Yes, we can hear you.
Yes?
Yeah.
Did your father just... Did he voluntarily stop representing Yabusho's, as an MP?
He did.
And concentrate on other things?
He did.
It was unheard of.
He did.
And he has provided leadership without being elected. So, following the same footsteps, show us leadership.
Okay.
Okay? Show us leadership. Do something decorous. Otherwise, we shall have to take things into our own hands. And then you will be picking up pieces of an indecorous approach. Okay? Do something. If you come back for these spaces when you have done nothing, we shall lump you up with those examples of bad legal and judicial culture. Show us something of exemplary legal culture. Bring that Kent University training onto full display by this time next week. Promise us here and now that you will find the words, put them in the right paper, so that the rest, you see, is a community like any other. When we have rising stars like you, with public mindedness, we must not invite you to complacency. Okay? It's quite dangerous. So we must also be as harsh on you as we are to those whose thinking and culture has brought us here. We shall not tolerate complacency. We can't keep talking. This is the 8th series. The 9th series must be about action and doctrinal fidelity. People must see what we mean by doctrinal fidelity. They must see it. So, enter your space, but I saw my young brother involved, they had to accompany. This is how we have been. We attacked him, me and Angulu. I had to put aside and share time So there you go. You don't have to give a promise or a pledge is enough for me. And then I can hold busy with this case and everything, but you have enough soldiers at your disposal. This, what do you mean by reggae, by the way? There are enough reggae fans. So show us something, and we believe. Some people can't believe
Lord sing.
when they're not holding something. I have to file constitutional petition number 16 of 2024 before I could start telling people that no general is a charlatan. Without filing it, they wouldn't put it. They would just probably say, this man is just wasting time. But they couldn't call me a time waster because I had put something in a system. I had shown them that this man is occupying an office in a society illegally. This man is an ambassador of colonial relics. He occupies the office that is supposed to be reading us from colonial relics. The department to read us of colonial. This man, the laws of Uganda revised edition nonsense to authorize miscellaneous provisions and everything. How many of you are satisfied that all colonialists are gone? It was a submission of my brother Eddie Nangulu that colonial relics are of the culture of proceduralism, which is the cause of backlog. What in Uganda, it may as well be the beginning of a sentence. Edison Karanga, you have a client who is a victim. An arrest here in Uganda means that all the rest of the remedies under the law are no longer in reach. That is why, as president of the bar, submit myself to your nonsense. Really? My brother Edison Kiza filed immediately to seek interim relief from an unlawful sentence. And he will get the answer after close to 90 days. 90 days, really? Yeah, that's it. It will be 3 days shy of 90 days. This is backlog, Edison. I am happy that we are alive to celebrate each other, because when I heard of the outcomes of the Mori Katanga Bay rulings, I called you and I said that's unacceptable. And you mustn't accept it. I don't usually involve myself in people's matters, but as always, you gave me time. We listened. And I told you, Edison, you do whatever you do, but the Legal Brains Trust is going to hold the judicial enterprise in Uganda as a whole accountable. We wrote our article. It's online, showing the judicial history. This is, how can a judge cite an Amin law? Section 14, 15, those things were introduced by Idi Amin to manage a problem of condoism that they had then. They should have been gotten rid of. Now, a Chief Justice proudly writes Chief Justice guidelines and reintroduces Amin things which a judge of the High Court, Edmund Lugaizi, had done away with in the case of Alai versus Uganda. Bail is entirely a judge's prerogative. Parliament has no business deciding for me how I should decide a bail case. Affirmative ruling. Just Shoba repeated the same thing. All that is now washed away. For lawyers, because you don't defend the principle, you don't curate the law. You treat it as donuts in a canteen. And you treat judges as, canteen keepers. You line up. It's break time in the sun. They are serving donuts with your cups. This is how backlog emerges. You are not defenders of principle. You do nothing. For us, we didn't do anything. We don't just sit there and legal brains to us to be sued. We sued the state of Uganda for its decision in the Mori Katanga case. I didn't need your permission, but as a colleague, I'm impressed that you encouraged me to try. It's a court which moves slowly because it's... But this is not about us now. It's about Vision 2060. Those who come in the year 2060 will find a decision challenging Uganda's main culture. Much pride, if I'm still there, I guess to be part of the hits and misses that define legal culture. Why the rest of you are there talking these things in WhatsApp groups? So, Edison, let us not reduce ourselves among us. Let's do something while we're still alive. Close with. We have given you our fire. You can't just ignore it. And hungry people. So what's the way forward?
You can.
Okay. Thank you for that. I had the president of the Law Society putting it to me the way I've been putting it to some friends of mine. In fact, one of the reasons why we have to close the space very soon is I need to go and plan to put some things to someone tomorrow. But I think the point... Yes?
Proceed.
Alfred, was that you or was that Isaac?
It was Isaac. You proceed.
Okay. But I think the point which you're making is a strong point. That we have to move from words into action. And you are saying, is it only when you get elected? Of course, being elected will also be good. Oh, can you hear me? I can be heard?
Yes, he has dropped off.
Okay, so I think the question was, how do we move this thing from words into action? How do we make sure that we are in a position to push this discussion forward? And I want to assure everybody who is listening, including the president of the Law Society, President Isaac Semakadi, I want to assure everybody who is listening that we shall certainly be moving very soon from thin paper into thick action. And we shall certainly be moving to a certain place and putting some ideas on paper, and not just ideas, but actually putting forward the case that we have been making in these spaces. The first stage of this argument has been about the attempt to generate a consensus through these conversations. The next step must be an attempt to enforce this principle of what you've called constitutional property, and we shall certainly be enforcing it. But now, take the assurance from me that certainly action will be taken for us to make sure that we enforce what we're doing. And with a few friends, we've already begun discussing certain things. It is, however, time for us to start winding up this space. It has been my singular honor, as someone famously said, and great pleasure to have you all here. It has been my singular honor and great pleasure to have the committee member for Eastern Uganda, Mr. Eddie Nangulu. Humphrey Hategeka was supposed to be on, but we had some technical difficulties, but I see he has stayed on throughout, and I'm sure we shall be able to engage with him soon. It has been my honor to have the president of the Uganda Law Society, Mr. Isaac Semakadi. President Isaac Semakadi, who has, as usual, put things to me
And with characteristic style, we shall make sure that we answer better than some of my friends have been answering. And it has been my great pleasure to have everybody here. It is said that it is good when brethren meet together in unity. It is said that iron sharpens iron. It is said that we create ideas from a marketplace by discussing them and refining them and sharpening them before we can deploy them into action. And we shall very soon be deploying these ideas into action. But for now, and from me, and from everybody here, allow me, colleagues and friends, to thank you so much for joining us, to wish you all a wonderful evening, to wish you all a wonderful evening. And as we say, on these spaces, every week and every Wednesday, from all of us here to all of you there, good morning, good afternoon, good evening, and good night.
It's coming to 11.